Hello everyone, welcome to the channel, Ontario Law and the Older Person, and I'm going to talk about two tribunal decisions. Tribunals are sort of like courts, but have different roles and handle different things, and it's about allegations of ageism that take place during the job. Most discussions about ageism, they come up after someone has been fired or forced to retire, or at least they feel they've been forced to retire, and that's where you'll get a lot more information about what kind of ageism can show up overall in a job. But these are two cases where they focus more on treatment that doesn't involve being fired or retired. The information provided in this video is not legal advice. It is relayed for the purposes of general information. No legal decisions should be made based on this material. Any viewer who needs legal advice should contact a lawyer. This is the first tribunal decision we're going to look at. Kara v. You might think of versus, but we actually always say and. York Catholic District School Board. So Kara is the applicant and he is suing the school board, which is the respondent, claiming that they denied him a promotion based on ageism. What I find interesting about this case is that the applicant, an older person, accuses the respondent of making decisions based on stereotypes about older people, but at the same time, he often leans in on stereotypes about older people in order to support his case. Now, he does ultimately lose, but it's also an example of sometimes the red flags are there, and I realize I've been using that term a lot. Sometimes when you look at a story and you see, oh, it's an older person, well, that is a red flag against the respondent. Oh, this is a person who was offered severance packages too often. It might be forcing them to retire. That's a red flag. So that's what I mean when I say red flags. So sometimes a story will have those red flags, a lot of reasons to think maybe ageism took place, but then the rest of the story might clear everything up. And I think in this situation, that's what happened. So this is from paragraph 2 of the tribunal decision. The applicant, and his name is Joseph Kara, is a teacher with the respondent board. Since the fall of 2007, he taught in the religion department at a high school, St. Robert, governed by the board. The applicant alleges that his age of 56 years and his perceived proximity to retirement were reasons for which the respondent did not offer him two positions in the religion department in 2014, didn't put the rest in. From paragraph 4, Derek Chan, the successful candidate for the 2014 acting and permanent positions, was also a teacher in the religion department and was 31 years old. The applicant had approximately 30 years of experience as a teacher, which was more teaching experience than Mr. Chan. The applicant alleges that his experience made him more qualified for the department head positions than Mr. Chan. So yes, we have some red flags. Mr. Chan is considerably younger, and while the applicant would be considered in many places an older worker, Mr. Chan would not at that age, and yes, having significantly less experience, also a red flag. Paragraph 5. The applicant also alleges that the respondent chose Mr. Chan because the interview process screened for someone who was well trained in technology and who had experience teaching in international, not going to try to say that word, IB programs. The applicant was weak in both areas. The applicant alleges that Mr. Chan had experience teaching IB courses because the respondent encouraged him and other young teachers to receive training in IB in order to teach IB courses. Also, younger teachers were disproportionately more expert in technology simply because they grew up with technology. So here we see a little bit the applicant kind of leaning on a stereotype to try to support his argument. From paragraph 6, the respondent asserts, however, that Mr. Chan was hired for both positions instead of the applicant because he performed better in the interviews and because his leadership abilities in the school were more observably impressive than the applicant's. And then this isn't from the decision, this is me saying both the applicant and Chan were considered qualified. This is from paragraph 12, and I've left some out, dots. Okay, so the judge is referring to another case that was about a different area of discrimination. That's my wording. And his wording, the test generally applied to establish a prima facie case. So is there a case that looks like it has some merit, basically, of discrimination in promotion slash hiring cases? A, that the applicant was qualified for the particular employment. B, that the applicant was not hired, in this case promoted. And C, that someone no better qualified but lacking the distinguishing feature, which is the gravamen, don't worry about that word, of the human rights complaint, subsequently obtained the position, in this case, age. So C might be the one we're fighting over because we know, or it's accepted, the applicant was qualified and was not promoted. Okay, the applicant's witnesses included, so this is my wording here, Dr. Ellie Berger, hope I'm saying that right. She had some expertise regarding the discrimination older people faced in the workplace. However, the judge found her research results out of date, that none of it had taken place within school board settings, and it didn't address the applicant's particular circumstances or how relevant people in the situation had behaved. So she hadn't observed anyone engaging in any of these activities. She was just kind of a random expert. So this is straight from the text, paragraph 8, skip some stuff. The applicant also called a vice principal to testify, Ms. Steele. She was the coordinator of the IB program at St. Robert's, and the applicant apparently hoped she would support his testimony about his unfruitful attempts to obtain training to teach IB courses from Ms. Steele's predecessor. The applicant never offered to explain why he called Ms. Steele instead of her predecessor to obtain that evidence, and Ms. Steele testified that she had no knowledge of what encouragement or decisions her predecessor may have made regarding the applicant. So again, we have someone who might have expertise overall, but she wasn't there. So she didn't witness anything. And the applicant is self-represented. And not sure why, but that's a problem when people can be representing themselves. They might not understand what evidence is and what witnesses are expected to do. The next bit is my phrasing. Another respondent, Ms. Sarnia, testified that IB training was available to anyone who asked for it. So what I'm reading from the text, the implication is that the applicants never did. She also said that having this training or experience teaching IB weren't necessary to get the position and weren't factors in the decision-making process. In addition, she hadn't known the ages of the applicants or discussed it during the decision-making process. Find it a little hard to believe that she didn't know the ages or have some kind of clue, but the panelist or the judge didn't seem to dispute this. This is my phrasing. The decisions were based on the answers the candidates had given during the interviews and the nature of the leadership the applicants had shown previous to positions being offered. They found that Chance showed superior merit in both of these areas. This is a paragraph straight from the decision. Paragraph 34. Ms. Sarnia testified that in their discussion about the applicants, they agreed that the applicant was not ready to take on the role of department head and that they had concerns about his interview answers. They put into question his ability to lead the growth of 21st century technology in the department and highlighted his inability to focus on a vision as a department head so that he did not succeed in answering certain questions. They also had concerns about his approach to students at risk or with special needs. So when it comes to their concern, he might not be able to move into the 21st century. Is that based on a stereotype or is that based on actual behavior? We'll wait and see. So from paragraph 38, I inserted there, one question was, ... The rest is the panelist, how he would lead the department in implementing the use of iPads. Ms. Sarnia testified that the applicant, instead of answering the interview question, talked about the dangers of allowing students access to the internet. She testified that he emphasized that caution was required regarding the internet for students, and that he said that because he is older and wiser, he would be the sober second thought in the department, suggesting that things should slow down so they could better assess whether technology was appropriate. So we have a bunch of issues here. The school had a plan moving forward with technology, and he was not going to help that happen. He was going to interfere with that. So he is also saying he's not as familiar with technology as younger people are, yet he would be in a position to say whether this was a good idea or not. And then on top of that, he's calling himself older and wiser. He's 56 years old. He's not 75. And that he is implying that he would be wiser than the people he was working with. Does that sound like a guy you want to work with? I find him a little obnoxious. From paragraph 35, Ms. Sarnia ... testified that Mr. Chan was able to address the interview questions better by answering the actual question and providing details that explained how he would get to the goals that he appropriately identified for a department head. So here's a long one. Paragraph 40. Another question, question 7, referenced the hypothetical situation where students approached the department head for assistance in creating a group that they wanted to call the Gay Straight Alliance. The question asked how the applicant would react and how he would support the students in meeting their needs. He answered in reference to an actual request made to him by some of his gay students in a similar situation, and said that he would have liked to have helped them, but that he did not have the time and energy to be involved with the group they wanted to call the In-Out group. The notes of his answer state that he sent them away. Ms. Sarnia testified that the applicant's answer was concerning because while he demonstrated recognition that the students were deserving of support and help, he did not answer how he would meet their needs. He also did not recognize that the situation was complex with legal issues at stake, and the best practice would be to bring in other staff to deal with the request. Paragraph 41, Ms. Sarnia testified that Derek Chan answered the interview questions well. Regarding question 5, she testified that the look-fors were met and that he spoke about working as a team and using the resources of the school. Paragraph 42, regarding question 6, Ms. Sarnia testified that Mr. Chan did not talk about any dangers of technology and instead referenced supports already in place, such as a teaching forum called DTL, Desire to Learn. And then paragraph 43. Regarding question 7, Ms. Sarnia testified that Mr. Chan answered that the students have a right by law to form the group, recognizing certain legal issues given new legislation. He said that he would do nothing alone but would consult with the school administration. He also said that he would bring in others, including someone from chaplaincy, to support the students in developing a plan. So I think we can see why Mr. Chan might be considered the better candidate. We have a teacher saying, I'm too busy to help at-risk students, and doesn't seem to understand or seek to understand what their needs actually are, where Mr. Chan has thought about this more thoroughly and he understands what resources should be brought to the table. My wording, the respondents also testified that they had observed Chan exhibiting effective leadership skills with both students and other teachers, including engaging and creating group activities. Meanwhile, the applicant, Kara, relied on examples of leadership that he had ceased engaging in. This is paragraph 61. The applicant argued that the question in each of the interviews requiring familiarity with 21st century information technology would be disproportionately more difficult for older teachers to answer because they were less familiar with technology than younger teachers. Also, he testified that only 21st century learning was required for the job, and while he chose to use such learning methods, he did not as readily choose to use 21st century technology. The applicant argued that any requirements that teachers use 21st century technology is a proxy for discrimination because of age, because older people were not raised with technology as children. It doesn't come naturally to us. This was mere conjecture, and I am not prepared to take adjudicative notice of these alleged facts. Don't worry about what adjudicative notice is. It's a whole other thing. Now, okay, so remember, this is 2019. This guy is 56, so he would have been born like at the end of the boomer generation, so he's near the end, near the beginning of Gen X. And while Gen X didn't grow up with all the technology younger generations are, the whole concept of computers, home computers, then into the internet, we had all that. I'm not quite as old as this guy, but we all had exposure to that and opportunities to learn. So he is, again, trying to rely on a stereotype to promote his case. Paragraph 62. Also, the applicant argued that younger people are more adaptable, although the applicant argued at one point that his inability to impress the interviewers was due to their perception that he was too old to adapt to new ways when he felt that he was adaptable. So here we have some internal inconsistency in his argument. Paragraph 63. The applicant testified that he believed that Mr. Nasello inserted the technology question on the interview sheet to disadvantage older candidates because it had not been a question in 2012. He believed that it was therefore not a standard question. He argued that knowledge of 21st century technology was not a criterion for the department head position and therefore should not have been a question at the interview. So, because 7 years ago this wasn't a question, it isn't a relevant question now. That seems to be what he's arguing here. And also, it's the school who kind of needs to dictate what the role entails. Now, is this an example of a neutral requirement that might be uh, particularly burdensome on older people? Or is it a legitimate requirement and therefore not a sign of discrimination? Paragraph 64. He led no evidence to establish that anyone believed that he was too old to adapt to new technology, and his assertion that the respondent did not train him or encourage him to learn was not true. And that is a finding, I guess, of the panelist. And then, for example, even the applicant admitted that he participated in desire to learn training, a method involving online learning, but he felt it was not something he would use because D2L, I don't know why I can't say that, requires a lot of time. And the applicant testified he prefers personal contact over virtual contact with students. He testified that he even becomes frustrated with projectors, which nobody uses anymore. I'm wondering, is this guy like me, where I'm pretty bad with technology and I might not be a good choice when it comes to helping people use iPads, teaching it to students. So, is age relevant if he actually lacks the requirement skills, not because he's older, but because he simply doesn't have that skill set? Paragraph 65. I find the applicant's testimony is unreliable regarding any strategy on the respondent's part to exclude him from learning technology. Also, I find that in the circumstances, any reliance by the interviewers on a candidate being able to answer the question well does not disproportionately exclude older teachers. Nor does such a question discriminate against the applicant because of his age. The applicant offered no evidence to prove his conjecture about older teachers being less able to answer the question than young teachers, and the board, as in the school board, had various training scenarios which the applicant could have accessed but chose not to use. Okay, very resistant to changes in technology. Let's think about the students for a second. So the board was trying to push forward with using iPads as a means of preparing students to do relevant kind of research with new technology. Here we have a teacher who was wanting to stand in the way of that because he's not good at technology. That's what it looks like. And is that good for the students? Then again, think this is from 2019. And now, I'm making this video in the beginning of 2026. People are very worried about students being online too much and frustrated with students bringing phones in. So, did this teacher actually have the right idea? Something to think about. The panelists found the respondents' evidence credible and their actions reasonable. So this is from paragraph 44, ... In drawing this conclusion, I note that it is not the tribunal's role to substitute its own decision for that of the hiring committee or to determine who it believes was the best candidate. It is the tribunal's task to determine whether the respondent has offered a non-code related basis for its decision that is sufficient to rebut the inference that a code ground may have been a factor. Ms. Sarnia's testimony is sufficient to rebut any such inference. So basically, we have the applicant saying decisions were made based on age. The respondent was able to provide a whole lot of evidence as to why they made the choices that they did. So we have a situation that looks bad at the beginning, but the explanations convinced the panelists that ageism was not a part. Now, I have made my position clear. I really do think this was a situation where they picked the best candidate. And I have to say, reading this decision, wasn't terribly impressed with the applicant's attitude. You might think something different if you were to read the case yourself. The second case is called Wilkinson and, obviously it's not the name of the business that will remain unnamed. It's just that I'll be criticizing this business. So if you want to know the name of that business, you'll have to go to the Canley website and check it out yourself. From paragraph 1, the application, filed on February 28, 2015, alleges reprisal and discrimination in employment because of family status, marital status, age, and association to a person with a disability contrary to the Human Rights Code. Citation: the applicant advises she was not proceeding with respect to the ground of marital status. So basically, initially, she alleged that she was being discriminated against because of her marital status, but she took that off the table at some point. We are going to focus on the arguments about age, not the other stuff. Paragraph 2, the respondent, so the business, requested a summary hearing, and by case assessment direction dated July 9th, 2015, the tribunal advised the parties that a summary hearing would be held by teleconference for the following reasons, and I'm going to skip over those. But a summary judgment is very early in the process, where one side is basically saying the other side, their argument has no chance of succeeding, so can we throw this out altogether? It's not a very common successful motion to get it all thrown out. In this case, some of it was thrown out, other parts not. This is from the decision, paragraph 6. The test that is applied at the summary hearing stage is whether an application, or in this case, part of an application, has no reasonable prospect of success. At this stage, the tribunal is not determining whether the applicant is telling the truth or assessing the impact of the treatment he or she experienced. The test of no reasonable prospect of success is determined by assuming the applicant's version of events is true unless there is some clear evidence to the contrary or the evidence is not disputed by the applicant. So again, it's not even about proving an argument. It's just, if it were true, could this succeed? Paragraph 7. However, and significantly, accepting the facts alleged by the applicant does not include accepting the applicant's assumptions about why he or she was treated unfairly. The purpose of the summary hearing is to determine if the applicant is able to point to any information which tends to support his or her belief that he or she has experienced discrimination or reprisal under the code. The question that the tribunal must decide at a summary hearing is whether there is likely to be any evidence or any evidence that may be reasonably available to the applicant to connect the unfair treatment allegedly experienced by the applicant with the code's protections. And I know that's a rambling paragraph there, but again, we're just stressing it's not even being able to prove yet. It's, is it possible to prove? Paragraph 11, the applicant worked as a house cleaner for the respondent company from January 2012 to September 26, 2014. The parties dispute the reason the applicant's employment ended, with the applicant asserting the respondent company terminated her employment and the respondent company asserting the applicant quit. Unfortunately, we don't have further detail about that scenario. I'm just speculating here, but maybe the applicant felt she was constructively dismissed. Basically, that the bosses made her job so terrible that she was forced to quit, and they're claiming, nope, she just quit. I don't know. I wish we had those details. So in paragraph 12, as well as 13, the applicant describes a lot of events, situations, what have you, that they are indicating are a sign of some kind of discrimination. But as I go through this list, could there be other reasons why this is happening, such as, bad organization or poor social skills, things of that nature. So from paragraph 12, the applicant sets out in detail many incidents she alleges are discriminatory, including not being given a uniform for 3 months, other workers failing to assist her with the cleaning when she was being trained, the owner of the respondent failing to make eye contact with her or communicate with her when she was working with Ashley, not being acknowledged for her 11 months of service at the 2012 Christmas party, only receiving a 1-year certificate of service at the 2013 Christmas party, the respondent not initiating a WSIB claim when the applicant was injured by a garage door, being given the driving responsibilities of a captain even though the applicant was crew. Paragraph 13. The applicant also alleges the owner promotes a youth culture where those with the least family and marital obligations are heard, respected, and promoted. Young workers come into work inappropriately dressed, slack off, work unprofessionally or inefficiently, are part of the in club, and are not held accountable, whereas two older workers, namely Judy and Linda, were reprimanded for being too slow. Ashley, who was 27, was promoted to the office in 2014 for a job that was not posted. Carissa and Alexis, who were 21 and 26, were working on their own within a month of being hired. Continuing with that paragraph, when the applicant worked with Carissa, she did not speak to the applicant or do her share of the cleaning. When confronted about her silence, Carissa replied it was just the way she was. And when confronted about not doing her share, she looked surprised, put her phone away, and began cleaning. And to me, nothing in that suggests ageism. Carissa might just not be a very social person in general or at work, and she could be just lazy, and we could have a bit of a clash of personalities here that have nothing to do with age. Amber, 27, was hired almost a year after the applicant, but had previously worked for the respondent, and after 9 months on the job was promoted to captain. Candace, 23, was made a captain after 4 months on the job, and dangerous driving was allowed by the owner who disregarded complaints from older workers about one employee texting and driving. The applicant also alleges she had to drive with an employee who talked on her cell phone while driving. So that last bit to me has nothing to do with ageism. And the first bit is the implication being made here that because the owner got complaints from older workers and not younger workers, that the owner was fine with his dangerous driving, or is it just a terrible employer who should be getting these people off the road? Paragraph 14, she submits that in her first year and a half of employment, she experienced no age discrimination but heard complaints about older workers being too slow. During that time, she was friends with Ashley, but when that friendship ceased, the applicant began to feel ostracized and excluded. She alleges Ashley did not like older workers, and the applicant once caught her talking with another worker about how to get rid of older workers, although Ashley assured the applicant she was not talking about the applicant. The applicant concedes she did not speak to the owner about this and concedes the respondent's submission that she had virtually no communication with the owner. So yes, if Ashley was actually talking about that sort of thing, that's a problem. Paragraph 15. The applicant further alleges other younger workers got promoted to captain positions while she did not. The respondent company asserts that the terms captain and mates were discontinued in 2012, but it could not alter the computer program to alter the service reports on which these terms were included. The respondent further points out that the applicant asserts simultaneously that the captain drives the vehicle, which denotes some status, and that she had to drive too often. I have to say here, I think it's pretty lame that the company couldn't update its software. This is years now. Also, the idea that being given extra responsibilities while not being recognized somehow is a good thing. I had a boss back in the 90s who tried to convince me to take on the role of a manager without the title and, more importantly, not the money. I wasn't in a grind culture. I said no to that. But I'm not getting the greatest vibe from this organization. From paragraph 16, the applicant further alleges that Ashley, who is young, was promoted to the office job which was not posted. The applicant disputes the respondent's position that the company structure is fairly horizontal with limited opportunities for promotion. She also disputes the assertion in the response that if promotions were given on the basis of seniority, there were 8 employees ahead of her. Because the office job opportunities were not posted, she disputes the owner's submission that it is possible that most older members prefer to clean rather than have additional responsibilities. Okay, is it fair to have job opportunities that you just don't tell everyone about? You just kind of pick someone and then they're hired or promoted and that's the end of that. Also, that's a pretty wild assumption on the owner's parts that, just making this generalized statement, older members prefer to clean than have additional responsibilities. Are there many people who would prefer to clean than have additional responsibilities that might result in more pay? Just a question. Paragraph 17. The respondent asserts that Ashley was hired by the owner's husband at ServiceMaster, not at the respondent company, and she was qualified for the job because she has taken business administration courses and worked part-time in administration at another company. Um, kind of wondering why it matters whether it was the owner or the owner's husband. They're clearly connected in some way. Anyway, moving on. Paragraph 18. The respondent denies the applicant's assertion that it promotes a youth culture and asserts in the response that the staff consists of staff between 21 and 65 years of age, and that of 15 staff, 8 are older than 40. Paragraph 19. The respondent further submits it has a mix of older and younger workers, many of whom are longer-term employees. Paragraph 20. The applicant further alleges age discrimination in that she and another older employee were excessively monitored after a customer complained about a cleaning job. The respondent counters that the monitoring was required because of the customer complaint, and it had nothing to do with the applicant's age. This is my wording. Almost all the allegations by the applicant were dismissed as having no reasonable prospect of success, largely because the applicant provided no details that, if true, could prove discrimination under the protected grounds of the Human Rights Code. These included all allegations in paragraph 12 and most in paragraph 13. So again, if we just remember a bit some of her accusations, the fact that younger workers don't dress the way the applicant likes has nothing to do with ageism. That younger workers slacked off has nothing to do with ageism. And then, of course, right there, we have a worker and a boss and an other employee who all might have different ideas about what hard work was. So that's the thing is, even if there's stuff she legitimately doesn't like happening, even if other people are kind of falling down on their responsibilities, that doesn't mean it's ageism. And the whole thing is, whatever negative behavior is happening, it has to be able to be tied down to one of the grounds under the Human Rights Code. So just being lazy, being a jerk, being irresponsible, that doesn't mean ageism. Paragraph 26. With respect to the further allegations of age discrimination contained in paragraph 13 above, many of those are vague and non-specific. For example, that the owner promotes a youth culture and that young workers are not held to account for their actions while older workers are criticized for being too slow. The applicant does not point to any specific evidence that supports discrimination against her on the basis of age as a result of these events, and as such, these allegations have no reasonable prospect of success. So the wording might be a little confusing. We're still not at a stage where things are expected to be proven, but there has to be kind of like a story. There has to be details that the applicant can refer to support her allegations, and it's looking like that isn't happening. Paragraph 27. In addition, the allegation contained in paragraph 13 above that two workers were able to work on their own within a month of beginning their employment has no reasonable prospect of success because the applicant pointed to no evidence that there was any link to the code. Maybe these workers were just so good that they didn't need this kind of supervision. The panelist does say that there's one issue that might be successful if things move forward. And before we get to that bit, I just want to introduce you to the concept of direct versus circumstantial evidence. And this is coming from this website. I liked the description. The link is in the description for this video. Warning, we will be talking about a violent act. This is a direct quote. Direct and circumstantial evidence are two fundamental types of evidence used in legal proceedings. Direct evidence links directly to material facts, such as eyewitness testimony or recordings of a crime, meaning it does not require any inference to establish a connection to the case. For instance, if a witness sees a suspect strike a victim, that testimony is direct evidence of the act. In contrast, circumstantial evidence requires the drawing of inferences to connect it to the material issue. For example, a credit card receipt showing the purchase of a baseball bat might indicate that the suspect bought the weapon, but it does not directly prove that they used it to strike the victim. But it's still an important piece of information. And usually most evidence is circumstantial. There's so many cases, especially before video cameras were everywhere, where the act itself was not witnessed in any way. So when you're watching TV and they're investigating something and they kind of dismiss, oh, the evidence is only circumstantial. Circumstantial evidence is still very powerful. Balance of probabilities. If the evidence is true, it is more likely that the accusation is valid than not. So basically, if the judge or panelist feels, yeah, pretty likely, then that person will win. It's a much lower standard than beyond a reasonable doubt. Basically, if it's more than 50% chance, and who comes up with those percentages, I don't know. But basically, if the evidence is true, then this event probably happened. Now back to the decision, paragraph 28. With respect to the applicant's allegation she was denied a promotion to captain, while two workers who were 27 and 23 were made captain within a short period of time, I cannot find on a preliminary basis that these allegations have no reasonable prospect of success. Because yes, it is a red flag when a significantly younger worker with significantly less experience gets a promotion that an older worker with more experience has been denied. So paragraph 29, I appreciate that there appears to be no direct evidence to establish age discrimination in this case. Nevertheless, the tribunal has long accepted that it is often difficult to establish direct evidence of discrimination and that the tribunal must draw reasonable inferences from circumstantial evidence to decide whether discrimination has been proven on a balance of probabilities. So what are they calling direct versus circumstantial evidence? Could it be said that this applicant overhearing commentary about not wanting older workers, isn't that direct evidence? Don't know. It kind of depends on the panelist or the judge to make those decisions. Paragraph 30. In determining whether the applicant can show a link between the proposed evidence and age discrimination, it is useful to examine what the applicant must establish in a full hearing, so a later appearance, on the merits to demonstrate a prima facie case. In cases involving hiring and promotion decisions, the tribunal has found the following elements to be sufficient to establish a prima facie case of discrimination based on circumstantial evidence. A, that the applicant was qualified for the particular employment. B, that the applicant was not hired, or in this case promoted. And C, that a considerably younger employee who was no better qualified than the applicant subsequently obtained the position, and then they mention other court decisions you might want to look at. Paragraph 31. Based on a review of the applicant's proposed evidence, it appears that the applicant can point to facts which would be capable of supporting the first two elements of the test discussed in those other court cases. The third element of the test involves evidence to which the respondent alone is privy to at this stage in the process. Paragraph 32. The tribunal is mindful of the fact that in some cases an application must proceed further in the hearing process simply because it is the respondent who has control over evidence which could favor the applicant's case. There also may be other information that may become available through the hearing process, which sheds some light on this issue. So for example, I'm suing a company. I know that company has documents that might support my case, but they won't hand it over. So this is the judge allowing an application to move forward in order to help that applicant get this evidence that they need. So because this evidence may exist, the panelist is letting this part of the process move forward. Paragraph 33, it is not clear at this point in time that this allegation has no reasonable prospect of success should the matter proceed to a full hearing. So yeah, these particular issues are possibly true and they would be possibly a link to violations under the Human Rights Code. Paragraph 34. The same cannot be said of the applicant's allegation in paragraph 13 above about Ashley being promoted to the office job. The applicant pointed to no evidence that she was qualified for the job, but stated only that the job was not posted and that no one was happy about this promotion because workers were needed on the road. Because the applicant points to no evidence that she was qualified for the position, she has not satisfied the first element of the test in those other court decisions. As such, this allegation is dismissed as having no reasonable prospect of success. So, the applicant does have a chance of succeeding when it comes to those other younger employees because they were not just much younger, but the applicant seems to have similar qualifications. In this case, with this other employee, the applicant didn't seem to prove that she had equal qualifications. This seems to rest on the fact that the job was not posted. But if we think back to the Human Rights Code, even the posting of a job, or even not the posting, but the invitation to apply for a job, that needs to meet certain standards too. And unfortunately, we don't have information about what the actual process was for inviting Ashley to apply for this job. That is detail that I would really like to see. Unfortunately, it's not written in the decision. So for me, there should be a bit more discussion about that. Is this process of just saying to someone, hey, apply for this job, as opposed to posting it to the entire organization, does that seem a little dodgy to you? Because as I've mentioned through this, I'm not getting a good vibe from this business. And I think maybe there should have been a little more investigation into who was talking about whom in one way or another. Anyways, that's the end of this video. Thank you for getting to the end and have a great day.